Good evening, class and participants.
All right.
Good evening, sir.
Good evening.
Evening.
So far,
I had a lady I was trying to get to come in here, but she's shying off.
well, she's a lady. She don't want to be in this group.
No, her husband, the cops came, the county sheriff or county over in Texas came over there and stole, well, they repoed a vehicle and the cop was there to help the tow truck, but it was on their property. And then this lady went up to the officer and said, "What are you arresting him for?" Her husband, he said, unlawful interference with the officer duty or whatever. But he ended up pushing her. She had to go to the hospital. He pushed her and hit her in the chest, and the officer did. But I guess she don't want to fight because she's not here.
What's an officer doing at a repossession? Isn't that civil?
No, that's no. Whenever a tow truck comes to pick you up, a lot of times they get the cops to come just in case there's some kind of issue. And but the officer, the guy, they didn't even know. Okay, first of all, it was on the truck driver. He owns the company, and the drivers had their vehicles at his house, and they were off in the trucks working. So they came on to their property, and since it was a repo, which the husband shouldn't have ever got involved. He should have stayed out of it, But he got 2 charges and went to jail. And because he's a permanent resident and not a naturalized citizen, they took him to jail. She had to pay the whole bond to get him out. And then they end up, the cop ended up pushing her, giving her a contusion. I don't get why she don't want to fight.
These people are getting more and more violent every day. It's unreal what's going on.
No.
I have the local. I watch my local police station's Facebook page up here, and the chief of police posts on it all the time, and he actually said that he posts stories of stops turning them into drug busts, and they're proud that they take a tail light that's out and turn it into a drug bust. And he posts the whole thing on Facebook, the whole story.
That's their whole goal, though, I thought.
It is, and it's that used to be like a secret with them, but now it's not even a secret anymore. It's just that's what they're saying they're doing now.
Every traffic stop is intended to be escalated into a DUI or drug bust. Every single one.
Without a shadow of a doubt. He basically says it right on the Facebook page for the Skowhegan, Maine Police Department. My jaw fell when I saw that post.
It shouldn't. That's the point. It shouldn't. It should be expected.
It is. I do expect it, but for them to say it publicly, this is what we're doing. Wow. You would think they would at least try to hide it. They used to.
Okay.
How you doing tonight, Eddie?
All right, and you?
Very good. I'm actually really happy I found your guys' class. I've been looking for weeks to find this thing.
Really?
Yeah, it's really difficult to find.
No, well, that's because
At least for me,
there's
it was.
not anything about it online except for how to sign up for a subscription on the Rule of Law site.
I tried doing that. I just couldn't wrap my head around it.
No? Easy.
Took me a little bit to find them too. I finally found, Eddie, one of your like one you had posted 24 hours before with Jane here, and
Yeah, that's actually how I found this one.
that email address right there. So
Yep.
And thank you so much for inviting me and answering me. I'm honored.
Who?
Well, let's see if you can hang.
Oh,
Now, just because there are going to be so many new people here in the class, I'm going to make one thing clear to y'all that I try to make clear to every new student. Under no circumstances are you to take anything I say in this class personally. It is not personal. If I insult you, if I ride your ass, if I yell at you, it's to make you learn. It is not to get under your skin and make you run away. If you can't go in there and be ready to be abused and expect it and know how to deal with it when you go into these local courts, you're going to get your ass handed to you because they will say and do anything they can to throw you off your game.
And
So if you're going to participate in this class, you better have rhino hide.
I got rhino hide.
Anything else, I'm sorry, I would love to have you, but you're not going to like this class because I'm not nice about it when you screw up. I try to use the Socratic method as much as possible. And when that doesn't work, well, then I resort to other measures.
That's why I'm here, because I'm a thick-headed Italian and sometimes I need to be smacked upside the head.
Well, trust me when I tell you, Italians ain't the only thick-headed people we're going to run into during this class. I don't think Jane's background is Italian, is it, Jane?
Oh, it's not. And he said the other night it took 4 oil bits to drill through.
Yeah, I love that video.
I've listened to a couple of Jane's videos and yeah, it's it's been,
I'm the punching bag, right?
It's
Well,
again, now see, that's
that
Jane making it personal. She says I'm treating her like a punching bag. I'm not. I'm trying to make her tougher while I'm trying to make her think harder.
But
Yep.
you're meaner to me than everybody else, though. You are meaner to me.
Well, can I be brutally honest for one more time?
You can't.
Everybody else doesn't fucking not listen as much as you do.
Oh, you just because all you're dealing with is just me.
No. Don't give me that. It's because bullshit. It's because you don't listen. And then you go do things your own way. That's the problem.
Because I'm tired.
It is just always the problem. I can't think of a single time I've crawled up your ass with a 2x4 that you have not been the problem.
Okay, well.
Thanks for the visual.
Yeah, well, you know.
No, but you heard him the other night.
It's how they make popsicles, right?
No.
That's true.
Just the other night, you got jumped all in my ass about not having an A in that statute, and then you ended up being see, you're killing me when you do stuff like that.
Having an A in the statute?
Or in the ordinance. Whenever you kept saying, well, there's supposed to be an A there. And I said, there's not an A, that's an E. And then you ended up finding out that I was right.
Well, the actual offense is in the E, or I'm sorry, the E 1, 2, 3. The offenses are in 1, 2, and 3. The framework for the offense is in E.
Yeah.
So what you originally said, I was equating with the number 1. But the feeding is actually in the E. So yes, you were correct in that respect.
Yeah, and you crawled up my ass over
But
there.
that's the problem with having to do everything from memory. I don't have the ordinance right in front of me every time I'm talking about it, but I've got the pieces of it committed to memory as much as I can with all the other shit I got going on. But that said, let's get this rolling.
Yeah.
Now, we are working on a cross-examination script for Jane's case, and I do apologize up front. I have had one hell of a messy-ass week, and I have not got to do any more work on it. However, Jane has been so kind to provide us with some canon material to start with this evening in relation to that. And so that's what we're going to do. The first thing I'm going to do is show you guys how to schedule a motions hearing. Okay? These are the steps. These steps are not to be deviated and replaced with the way you would rather do it. These are the steps. Can everybody see this screen?
Yes.
To schedule a motions hearing on your file pleadings, do things this way. 1, you ask the clerk to check the court calendar for 3 different dates and times that are open. Not were open, are open. Meaning the court has nothing else scheduled for that day at that time. They may have other things for the day, but they don't have anything scheduled for that time. Okay. And depending upon, and I can't put anything on here about how much time you need because it's going to vary depending upon how many motions you file that you want to get heard and how big they are and how well you can argue them and how on track you can stay while you're arguing them. So the length of time you need may be varied, but you need to pick a time that is minimal as possible. If you tell the court you need 4 hours for a motion hearing, they're going to look at you like you lost your freaking mind. You schedule anything more than an hour for a motions hearing, and you're likely not to get it.
Okay. Also, you need to ask the right clerk, I'm thinking.
A clerk of the court is a clerk of the court. They all have access to the court's calendar. They all know what the court is scheduled to do because they can all look it up.
So he was just playing me. Okay.
Being
Now,
nice is very
the
helpful.
judge's secretary or the judge's personal clerk may have a different schedule for the judge themselves, but not for the court.
Okay.
You're not asking when's the judge not playing tennis or having a dinner break. You're asking when is the court got a free hour on any given day.
Oh,
and
yes.
every clerk there should know that.
All right. Well, I didn't ask it like this. That's why I probably. But
Well,
anyway.
no shit, Sherlock, despite me telling you how many times in class to ask it like this.
I knew that's what you said to do, but go ahead.
Number 2, once the clerk has given you 3 available dates and times, then you determine which of those dates and times is more convenient to you. You're not looking to be accommodating to the other party. You're looking to be accommodating to your schedule. Schedule it that way. If none of the dates and times are convenient for you, then you ask the clerk to try and find 3 other different dates and times. They can be further out in time if necessary. Okay. 4, rinse and repeat step 3 until you find a good date and time and ask the clerk to schedule the motions hearing for that date and time.
I did it the other way around. I gave him the dates that I wanted.
Without a clue of whether or not the court calendar would accommodate those dates.
Oh, but I didn't give him
And therein lies the problem.
weeks. Like a week here, a week there.
Okay. Now, let's go to number 1 here real quick. Jane, what is the reason that you needed them to set this for a different date?
You talking about the pre-show hearing or pre-warrant hearing or whatever?
You had a specific reason why you couldn't be in court on a specific date. What was what is the reason?
I told them that I was going to be out of
I'm
town.
asking you to tell me now. Answer the question I'm asking you.
That's what I just said. I said all I did was say I'm going to be out of town on this date.
Okay, that's the only answer I want out of you then. I said I'm going to be out of town.
Yeah.
Okay, great. Take that and look at number 1. Knowing you're going to be out of town on a given date through a set of dates means number 1 should start off by asking for what?
Asking for 3 additional dates or 3 open dates.
3 open dates when, Jane?
When they have available, but this is not for the motion that I'm asking for. This is for
Jane, stop telling me what this isn't for and just answer the question I'm asking you. This is where you and I have a constant disconnect. I'm not asking you for an explanation or varied input. I'm asking you a specific question. Answer the damn question.
What's the question?
I really should invest in migraine medicine. I won't keep doing this class. All right. If you're going to be out of town at a given date and time or through a different date and time period, then when you go in and ask for your dates, what should you make sure you ask for?
for the clerk to check the court calendar for 3 different dates and times that are open. I don't know what else you want me to
And
say.
how does the information about your being out of town play any part in that, the way you're saying to do it, Jane?
Oh,
Why would I need to know that? And even more importantly, why the hell would the clerk know when you're going to be out of town?
I'm saying, okay, I guess, does anybody else understand what he's asking of me? Because I don't understand. I thought he said, what is the thing that I would ask the clerk if I was to tell them that I'm going to be out of town on that day?
He wants to know
They
what
don't
the
need to
correlation,
know.
yeah, between you going out of town and you asking them for 3 dates. Well, how do you think those two things are alike? Why does one have to do with the other? Why should you keep in mind the dates you're going out of town and the dates you're asking the clerk for dates the court's calendar is clear?
Damn, I like Heidi.
Well, I don't see how. I understand that, like, if I'm not going to be there, then I have to have a different date. So I don't understand
What do you mean by I have to have a different date?
If I really was going to be out of town, then I would need to have a different date scheduled on the court calendar.
Which means number one should be taken into consideration and asked for how.
I'm going to be out on June 1st. Please advise of any other dates other than that date that is available to me. Thank you.
Let's simplify that. Find another way to say it that doesn't confuse the clerk or yourself, for that matter, for asking it.
If I know I'm coming back from my trip on August 3rd, I'm going to say, can I have 3 open dates from the court after August 3rd, please?
There you go. Can you please find me 3 dates that's got at least an hour's worth of open time that are after August 3rd? That's it.
I don't have to tell them I'm going on a trip. I just have to say, here's where I need my benchmark.
No, you can say I have to be out of town for work or a family matter or anything like that for this period of time. Therefore, I need to get 3 available dates and times after the date I'm expected to return.
But do you have to necessarily volunteer that information?
You don't necessarily have to volunteer why you're asking for the dates to be beyond a certain date, but it may make them more amicable to looking.
Yeah, and
Right.
sometimes they actually do seem to need a reason on some cases I've noticed. So,
Well,
Right.
if it's something like a lawsuit or it's in a different court, but traffic court's a different animal.
okay.
Right. I know Jane said something about when she calls them, she tells them what dates she wants. So I was gonna
Yeah.
say, like, you could just wait until you hear the dates that they give, and it may not even coincide with the time that you're going to be out of town.
No, see, this is why the disconnect is because Eddie is talking about when we go schedule a motions hearing. This is totally different from them setting a pre-warrant status hearing or show cause hearing for you to come in. And they've already predetermined that. I already knew when it was supposed to be. I'm saying, and I waited until like a week later, and then all of a sudden I'm saying, I'm going to be out of town that day.
And when they schedule something for a time that you're going to be out of town, what do you need to file?
A motion or a request to have 3 different dates to schedule a new hearing.
No, Jane. They've already got the date in mind they want you in court. What do you have to file when they do that if you aren't going to be available?
Motion for continuance.
There you go. A motion for continuance.
Well, truth is, I'm not going to be out of town that day.
Well, then guess what would happen if you filed a motion for continuance and it's a lie? Because guess what you have to do in the state of Texas?
I don't know.
A motion for continuance must be signed under penalty of perjury.
Well, I'm not gonna. So then I went to instead of calling them or doing anything, I just went up there and I told the guy, "Can you have the clerk look check the court schedule to see if these dates that I
Well,
have."
who were you talking to if it wasn't a clerk?
It was a clerk. It was a clerk, but he acted like he didn't take it. He was like he took it as a motion, and that my piece of paper that had the 3 sets of dates, and he stamped it and made a copy, and he says, "I'll send this to the court or to the judge." And I'm sorry, I was okay. Well, I didn't expect that because I don't know if all of them schedule.
What you do, Jay, and say, excuse me, but why would you file my personal notes with the court? Why did you take it and act like it was something that belonged to you? Can I have that back, please? I didn't bring it here to be filed.
Yeah.
What's wrong with doing that, Jane?
I should have said that, but instead I asked him if the judge had replied to my email saying that I wasn't going to be here for the 23rd, and
No, the judge is not going to correspond to you by email. Which part of ex parte communication do you think that would fall into, Jane? If you want the court to do something, there's only one way to move the court to do it. Anybody?
I didn't send the judge. I replied
Through
to
a motion.
Throw a motion.
yeah.
Every time you want the court to do something that you want it to do, you put it in writing and you call it a motion. That's what the fucking word means. I'm moving the court to take this action. Anybody not understand that part of it?
Yeah, I understand it.
Okay? That is how you get the judge to respond to something. You don't do it with a fucking email.
I didn't send it to the judge. But anyway.
Again, Jane, the judge can't respond to it.
Well,
and he can't take information from his clerk about something you're asking him to do because the clerk could misinterpret it.
Well,
you're the one that has to ask. And how do you ask?
Well, isn't the judge supposed to look at our motions? There are motion to quash.
Okay, explain to me how you equate an email with a motion.
I'm saying you're saying that he.
Explain to me how you equate an email with a motion.
I'm not. I already told you what I did.
Then why are we talking about a motion when we started out talking about an email you sent?
You said the judge was supposed to, he is required to respond to a motion. I'm saying that he's not because he doesn't. He hasn't.
Well, that's a separate issue, Jane. But he's definitely not required and isn't going to respond to an email.
I will send him an email.
Did the email ask the judge do something, Jane?
No, the email did not ask the judge to do.
Then what did it do?
It was in reply to their sending me a pre-warrant notice in the email. And that's when I told them that I was not going to be available that day. I just replied to their email. That's all it was. I didn't write anything else in there.
And you expect that to get you what? You said you asked the clerk if the judge responded to it. Did you not?
Yeah, he said that a judge.
Then you sent it back with the expectation that you would get some action out of the judge. Did you not?
I did that, and then I knew I was going to go follow up with it and go down and talk to them in person. That's why, and then so I did, and that's what happened. But
ladies and gentlemen, what is rule number 1 of interacting with the court? Absolute, uttermost rule number 1.
Get it on recording.
Do it all in writing.
Everything is done in writing. Every single thing. The only thing you don't do in writing is go down and get a copy of the court record. Anything
I learned
else
that.
you're asking anyone in that place to do, you submit it in writing so there is a record. That is how you make a record. He said, she said, I asked, they responded, didn't answer, blah, blah, blah. It doesn't matter if you can't prove any of it because you didn't write it down, you didn't submit it in writing, or you didn't record it. Or you recorded it, but for some reason the court says, I don't want to hear the recording because I think it's inadmissible and don't want to know. Now what are you going to do? Because as the clerk, what's that?
Write it down, send it in.
You write it up as a motion or a brief and you send it in. Okay. Everything must always be done in writing if you're going to make a record, because the record is the only thing you've got when you go to appeal. You don't get to make new argument. You don't get to present new evidence. You don't get to say and do a damn thing unless you specifically ask for oral argument on appeal. And then guess what? Even with oral argument, you are limited to exactly what was proven, not proven, or submitted in the original trial. You cannot go above or beyond that information in any way whatsoever.
That family don't need to.
If you do everything in writing, you won't need to. But if you keep flying around by the seat of your fucking pants and crashing your head into the wall every time, you're not going to survive long enough to get to appeal. And that's the problem.
Appeals court's not going to do
Most people lose their case because they self-destruct long before they ever set foot in court. And they self-destruct by not knowing how to do something or what to do in the first place. That's how you lose.
I got to go two courts up before anything will happen with this case.
How do you figure that?
Because the next court up she's a criminal just like they are. I've already dealt with her.
What court is it, Jane?
Dallas County Criminal Court of Appeals 1.
Is it a municipal court or is it a county court at law?
It's not a county court of law. It's the Dallas County Criminal Court of Appeals number 1. There's only 2 of those. I sent you the exact court. Oh, you asked me for it, and I sent it to you.
Dallas County Court of Criminal Appeals?
Yeah, number 1. That lady, she's just as corrupt as a municipal court. So I'm gonna have to go to the 5th District Court of Appeals for anything to happen. A lawful court.
Kristen Wade?
Yeah, her.
$11 county criminal courts and 2 criminal courts of appeals. But supposedly the criminal courts of appeals have jurisdiction over cases that deal with class A and B misdemeanor offenses, not C's.
No, that was the number 2 has over A and B, and she does class C. She might do A and B too, but I know she does class C because that was already the court that I had to go to before from this court. She didn't deny that she didn't say that I was in the wrong court when she denied my writ of Mandamus. Only thing different now, though, is she might have been in cahoots with that Rodney Adams, the judge.
Guess
Adams.
what?
What?
According to this information, the Dallas County Criminal Court of Appeals, number 1, does not have jurisdiction to hear appeals in Class C misdemeanor cases that are fine only.
Because I know that for a fact it's in there unless they changed it this year. It says it in the government code, I think.
According to this, you're supposed to be going to the county court at law in Dallas County. That's who hears your appeal.
What are you looking at?
The internet.
I know, but what? The Texas statute?
A Google search.
Okay, well, that's wrong.
Really? Then show me the statute that contradicts it.
All right. I have to find it. Hang on.
See, this is the problem with not keeping track of things that you've found once already that might actually contain useful information.
I've been to that court before. I already know that that's the right court. And I don't trust.
No, Jane, just because you've been there doesn't make it the right court.
It is the right court. Let me see here.
While you're at it, can you check County Court at Law number 2 in Jefferson County? I wonder if that's something we overlooked.
Anyway, y'all can go on and do something else while I'm trying to find it.
Well, you can edit this search string right here.
Which I'm not seeing it, Eddie.
I'm fixed to put it in the chat. Hang on just a second.
Go to government code, municipal courts of record.
Put that in Google and change the county and the name of the court as appropriate.
If there is no county criminal court of appeal, or municipal court of appeal.
What's the statute, Jane?
I just told you, section 30 of the local Texas government code, section
government
30,
code or local government code?
Government code. I don't know, it's a government code. Let me see. It's the government code. For chapter 30 for the municipalities, section 30000014. It says,
hang on. Let's see. You said 30.00014 appeal?
yeah, and it down there it says if there's not any of these courts, then let's see, if there's no county criminal court or no county criminal court of appeal or no municipal court of appeal, the county courts of law have jurisdiction of an appeal. If the county court does not have a county court law under chapter 25, the county court has jurisdiction of any appeal. But that's not where I saw it then. Let's keep reading because it's not, maybe it's not right here, but it's somewhere else. It's in the appeals, appellate procedure or something. Hang on, I'll find it.
Is that the government code for the United States or just Texas?
Oh, Texas government.
It's Texas.
Okay.
Let me see here. I mean, they could have taken it out of the government code. Let me see. It might have been in the rules of appellate procedure, though.
No, it's here. What you're talking about, the statute for the appeal.
Yeah, I know, but does it say what I said it said?
The county criminal courts or county criminal courts of appeal in the county in which the municipality is located or the municipal courts of appeal have jurisdiction of appeals from a municipal court of record. If there is no county criminal court of appeal, or municipal court of appeal, the county courts at law have jurisdiction of an appeal. If a county does not have a county court at law under chapter 25, the county court has jurisdiction of any appeal.
So since we do have a county court of criminal appeals, that's the reason why that goes there.
Well, the thing about it is you have to see if this is limited to a specific municipal court.
No, I found out when I went there. They even scheduled me for a hearing and everything. So she even ruled on my mandamus and everything. So I was in the right court.
Again, Jane, I've watched courts rule on things they didn't actually have jurisdiction over.
And then I appealed to the 5th District Court of Appeal from that court.
I found something on mine. I can tell you. Jefferson County, Texas has 2 county courts at law numbered 2 and 3. that primarily handle misdemeanor criminal cases, including Class A and B offenses like DUIs, thefts, and assaults. These courts also hear appeals of final rulings from the Texas Workers' Compensation Commission. Additionally, they have concurrent jurisdiction with district courts in civil cases where the amount in controversy ranges from $500 to $200,000.
Okay, Jane, in
Right.
your case, 30.00014 is not the statute you need to rely on. It's subchapter C of that same chapter, which is 30.00081.
Okay.
This subchapter applies to the city of Irving. In this subchapter, appellate courts means the county criminal courts of Dallas County that have criminal appellate jurisdiction. You got to remember, chapter 30, what you read at the top is a general declaration, but chapter 30 is full of specific municipal courts created by the legislature. And those take precedent over everything. The section that is specific to that court supersedes the general section at the very top of that chapter.
So it's 8-1. Let's see here.
00081. Yes, 30.00081.
So I'm still in the right court, right? County Court of Criminal Appeals.
According to this, yes.
Yeah, because I've read other appeals from this court, other cases that have appealed from this court to that court and actually got all the way up
Well,
to.
again, Jane,
Yeah.
if you went into her court the same way you've gone into the trial court, I'm sure she does have a chip on her shoulder when it comes to dealing with you. This time, go in there smarter and more knowledgeable and doing things better, and maybe she won't have that problem with you.
She didn't have a problem with me. She never met me. They scheduled me for a hearing. Then when I got there, they said, "Oh, the judge is not even here. We didn't mean to send that hearing notice out." I had already filed an application.
Okay. See, this is why you confuse me and why you upset me. What did you say about the judge of this court at the very beginning of this conversation when we got to the issue of your appeal?
Judge of this court.
Called her a criminal.
Yeah. They are criminals. They're all criminals. But what's your point?
My point is you don't know a damn thing about this judge, do you?
Yeah, I do.
Such as?
She ruled on my application for writ of mandamus, and I didn't like her ruling, and she responded.
Does that mean she's wrong because you didn't like it?
No, I'm saying also too. I filed a petition for writ of mandamus, and then I had to go out of town. I was visiting my mom in Arkansas. They scheduled.
Jane.
No, listen. They scheduled a hearing for me to come in there and have an oral argument on the freaking mandamus. And then when I got there, the clerk tells me that they sent that hearing notice out by mistake and that the judge was out of town. And so anyway, she ended up responding in writing and denying my application for a writ of mandamus. But I didn't like the way that she ruled on it, and so that's the reason why I'm calling her a criminal. And she wasn't supposed to dismiss my appeal without
Jane?
me. The whole she's criminal. She's criminal.
Stop. Stop. First off, you said now, correct me if I'm wrong. I want to make sure I am not messing this up in any way. You said that she ruled on a writ of mandamus motion, right?
Yes, she did.
You filed a writ of mandamus in the Dallas County Criminal Court number 1. Criminal Court of Appeals number 1.
Yes, I did.
Okay. Let's see.
You want to know what I filed it for?
Hang on just a second. 22.221. $22.221. Okay. Now, I want to ask you a simple question. I don't want you to try to answer it right now. I want you to go find the statute and figure it out from there.
Figure what out?
What I'm about to ask you.
Hmm.
What courts in Texas have mandamus authority? Now, let me explain why that's an important question to answer.
I wouldn't have followed it.
You done?
Yeah.
If you file a writ of mandamus in a court that does not have mandamus authority, the court cannot rule on your mandamus beyond saying denied.
Bingo.
Because they have no authority to rule on the mandamus itself.
You ruled on it. Obviously, she had it.
Thank you. You actually just answered what I had a suspicion of.
Jane,
What?
once again, she doesn't have mandamus authority.
She does. I don't know where you're getting that at, because I figured that out before. I wouldn't have even followed it there if she didn't.
Really?
Yeah.
Then why don't you go read section 22.221 of the code of the Texas Government Code?
Okay, they probably changed it since then, but anyway.
No, Jane, this is what it says right now. And this is what it has said since at least 2023.
Okay,
That
well,
was the last time it was updated.
I think it was before then.
Let's see.
So 22 what government code 22 what? Appellate courts?
22.221 writ power.
That doesn't say what kind of writs, does it? Could be habeas corpus.
A writ of mandamus is the only writ we're worried about here.
Yeah, I know, but this could be a writ of habeas corpus.
No, Jane, it specifically says mandamus in the statute.
Each court of appeals or district court. All their writs necessary. I can't see it because the thing is in the way. Oh. Okay, I'm not seeing anything yet. Each court of appeals for a court of appeals district. Other than court of appeals. Judge of district court, associate judge of district court, county court. I'm not seeing it what you're talking about. You're saying this is all, it's listing all who does have writ power.
$22.201.
Mm-hmm. I know she had writ mandamus power.
Court of Appeals districts. Now, you said this was
It's not a district.
the Dallas County, right? Dallas County Court of Criminal Appeals.
Yes, number one.
Okay, under section 22.201 of the Government Code. Okay. There are 14 courts of appeals districts. Okay. Those courts and the courts above them are the only courts with writ power.
Okay, well, let me find my motion right quick, because I approved the jurisdiction and the venue and all that crap in my mandamus. So, let me see here.
That doesn't mean you got it right either, but let's hear it.
Well, she
again, Jane, I'm not worried about what she says or does. I'm worried about what the law says. So let's start there. Then we'll worry about what she did.
Also, too, the courts tell you if they don't have writ power, and also the district court above her
Jane,
would have
just
also.
find your motion and tell me what you put in there.
Oh, hang on, I got it right here. All right, let's see. District Court venue and jurisdiction of County Court of Criminal Appeals 1. Texas Government Code Section 30.0002. And Texas Rules of Appellate Procedure 25.2, criminal cases. Texas Code.
That's to hear the appeal. That's to hear the criminal case. Where's their jurisdiction to hear a writ?
I cited Texas Government Code Section 30.0002 at the top. Let me see.
And what does 002 actually say?
I don't know. This was way probably before they changed it.
I don't think they have changed it, Jane. Okay.
All I know is she ruled on it. She didn't say she didn't have writ power, and neither did the Fifth District Court of Appeals after I appealed, did the same thing to them after her. They didn't say, none of them said we don't have writ power. Why would they?
There's nothing in 30.02 that says they have writ power.
Well, maybe it changed.
And Chapter 30 is all about municipal courts of record. Municipal courts don't have fucking writ power. Okay? And that's what this deals with. The appellate court here also is not in 22.201 as a court having writ power. So the Dallas County Court of Criminal Appeals number 1 does not have writ authority by law. Everything that you cited is definitions, Jane. There's no authority given in 30.02 for jack shit. It's a definition section. And all it says in relation to an appellate court as a definition is what courts it's talking about. And that's talking about an appeal from a municipal court of record, which is what this whole freaking chapter deals with.
But I didn't have.
There is no but.
I didn't have a normal appeal. I didn't get to appeal the normal way. I didn't get to appeal because I screwed up the appeal. But the reason why I went to her is because she was supposed to rule on my indigent status because the municipal court was
Jane,
not. No,
stop.
I'm not.
Stop. That has nothing to do with what we're talking about.
It does. The whole reason why I went to that court is because I was trying to get her to rule on my indigent status so I could get the appeal, because that's where I screwed up. And it says in the Code of Criminal Procedure or in the government code.
Okay, here we go, changing the story again. What does a writ of mandamus have to do with a fucking...
That was the whole reason for the writ of mandamus. It was
you wrote a writ of mandamus to try to get the court to rule on your indigency status?
Because it says it in the Code of Criminal Procedure or in the appellate procedure that
if you file it with the right appellate court, that might apply.
It was the right appellate court.
No, it's not, Jane. I'm sitting here telling you the statute says it's not. It's the right court for the appeal for the trial. It is not the right court to file a writ of mandamus. Those are two completely different things.
He thought it was, and so did the Fifth District Court of Appeals.
Well, what she thinks is irrelevant.
Well,
how you filed it may have impacted why she thought she had the power to do it. But if you filed an actual writ of mandamus, she had no legal authority to hear it. Period.
Well, she wrote an order.
She may have written an order, Jane, but that doesn't mean that you filed what you think you filed. And therein lies the problem.
courts usually say they don't have writ power. They don't just let you get away with and taking up their time.
No, Jane.
No.
They will only do that if they completely understand what you're asking for.
And she wrote in there what she thought I was asking for.
Did she say she thought you were asking for a writ of mandamus?
She responded to my writ of mandamus saying that I wrote a writ of mandamus. And so just like
And how did she rule on your writ of mandamus, Jane?
She denied it. And that's
right. Which, as I said, if she lacks jurisdiction, is the only ruling she could make.
Bullshit. That's not why she denied it. If you want to see it, I'll show it to you. That has nothing to do with what she denied it for.
That's your understanding of what she denied.
No, I know why she denied it.
Really? Why?
Because she's a criminal.
There you go.
Because I'm trying to fucking tell you, listen, there is a statute or a rule or a freaking article. I don't remember what it is. I don't know off the top of my head because you're pissing me off right now. It says that the municipal court cannot not allow you to have an appeal if you're indigent based on the fact if you missed the hearing or whatever. They still have to, the appeals court actually has to give you a hearing and they have to decide on the indigent status so that you can.
That's a separate issue, Jane. It is still not a mandamus.
That's still the reason why I filed the writ of mandamus. So I was trying to get her to force the court, the lower court, to hear my motion. I'm not my motion, my status of indigency. And I tried to get her to force them to hear it, but since they couldn't dismiss my appeal based on that, and she wouldn't do it. And she did say it, and it was a response to my mandamus. She thought she had
again, Jane. You filed what you think is a mandamus. That doesn't mean that's how the court interpreted. She has no legal authority to rule on an actual motion for a writ of mandamus. Mm-hmm. The statute is very clear about that. She doesn't have it. So the only way she could have ruled on an actual mandamus is to deny it, saying, I don't have the jurisdiction to hear it.
Oh, she didn't do that.
Okay. The other is to say this isn't really a mandamus. What you're really asking for is this.
Nope. I'll find it right quick. Let me find it.
I don't care if you find it at this point.
Of course you don't. Because it's not neither one of those things. Of course you don't want me to prove it to you.
It's not a matter of whether you prove it to me, Jane. You're trying to convince me of what you think you filed.
No,
and without actually sitting down and talking with the judge, there's no way to understand what she was thinking you were thinking.
Except for she wrote it down.
Fine. Then send it to me in an email. I'm not going to chew up any more time in this class on it.
Fine.
The point here being, okay, that just because you file a document doesn't mean you filed it in the right place, and it damn sure doesn't mean you're reading the statutes right. And therein lies your first problem.
All right. Well, nobody else can do it right.
You quoted, Jane, I just told you, 30.quad02 says it's a definition section. There's nothing in this section that deals with what jurisdiction a court has. Nothing. How is that reading the statute correctly? To you to say that this is where your jurisdiction comes from, court?
Well, no, I'm hoping that's the right mandamus that I actually filed.
And if you made that mistake, how am I supposed to turn around and interpret how you're saying you did everything else as not being a mistake? When I see the other statute, 22.201, saying that court cannot hear a mandamus. That doesn't leave me too many doors to choose from on which option this is. Now, that's what's in the statute. I don't care what you think if it doesn't jive with what the statute's saying. Because the statute is going to win, no matter what.
It was probably changed.
Well, let's see.
Or it could have been 30.00.
102 has not changed since 1999.
What about 00014?
And 22.201 has not changed. It wouldn't matter when it was changed. because none of these are all the same courts of appeals. The only thing they've done is create additional district courts. And it was that way since 2005. And then they added a district court in 2023. The Dallas County Criminal Court of Appeals has never been on this list of courts that have writ power. Never been. These are all district level courts or higher. Every one of them.
Okay. Say so.
I don't say so. The statute says so. Every one of these. The 3rd Court of Appeals District, the 4th Court of Appeals District, all the way down to the 15th Court of Appeals District. They're all district level courts. The only thing above that are the actual courts of appeals and the Texas Supreme Courts.
Her response.
So, as to the rest of the class, now you can see why this class has some of the issues it has. You read something, you misinterpret something, and you don't realize you misinterpreted it because you took it and how you understood it the first time. This is why it is imperative that you don't read a statute once, twice, 3 times. You read it multiple times. You break it down every time you read it. If you don't break it down, you will not understand it. If you don't consider the context in which it's located, you will not understand it. So that means you don't check just the statute. You check where in the code the statute is located. See what section it's in. What's the title of that section? What does everything else in that section talk about? All of that matters.
All right. Well, I'm looking at the motion or the writ of mandamus to the 5th District Court of Appeals now, and that has different authorities or whatever.
Yeah, the 5th District Court of Appeals actually has writ power.
Yeah, but it's the appellate court. I cited what the appellate court was. Dallas County Criminal Court of Appeals 1. And then the original proceeding to the cause is a misrecorded record, and this one is petition of writ of mandamus, and then they actually ruled on this one too, and they gave all kinds of explanations in there, just like she did. It has nothing to do with them not having writ power. Neither one of them said anything like that.
The 5th District Court would have writ power, Jane, is my point.
Well, she didn't say anything either about not having it. So, but anyway, so I cited a bunch of case law, but I cited Texas Constitution, Article 5, Section 8, and I'm not saying that was to prove venue or anything. Statutes I cited were Government Code 22.2221 and Government Code again 30.00014. Code of Criminal Procedure 1.27, and then a whole bunch of rules of appellate procedures and the Texas Rule of Evidence. And then also,
Eddie, can I ask a question about some clerk stuff? This is Chris, by the way. Okay.
Sure.
There seems to be, we're going in circles here about getting access to the proper court, but is there any reason a clerk can't give you some direction as to this?
Yes. The clerk is not allowed to give legal advice, and telling you what court and where to file things is giving you legal advice.
Okay,
you're
what about
the one that's required to understand the rules if you're going to act as your own attorney, just like the attorneys are expected to know. The attorneys have to know what court to file something in, and if they don't, they have to figure out how to correct their mistake. You are not going to be given any consideration any different than they are. The clerk cannot tell the attorney where to file it. Now, he can say, oh, well, that's the office down the hall, not this one. But he can't say, oh, no, that doesn't belong in this court. This belongs in that court. The judge can say that, but the clerk can't say that.
Okay. All right. So that's understood. I get that part of it. now I have a question about clerks because I was just wondering what your experience might be with this. I filed several lawsuits on my own. Generally don't have much problem, but I'm learning some behind the scenes stuff. And it seems the clerks intervene a lot. Have you had experience with that? And then they relay information
Define
to the judges.
intervene.
They will read your pleadings and even, well, especially motions, and relay to a judge what it may be. And the judge sometimes will take that as being advisement without going through the whole pleading themselves and sign off on it.
And explain again, define sign off on it.
Well, the judge eventually signs. Now, I've seen motion pleadings be signed by clerks, and this is the thing that confuses me.
Okay, again, signed in what way? As a ruling upon the motion?
Correct.
Clerks don't have the power to sign rulings. And the judge can't give them that power.
Well, I have two motions for extension of time recently. Now, keep in mind, this is in the 10th Circuit. That there's judge's name at the top, but the signature at the bottom is by the
10th Circuit
clerk.
state level or 10th Circuit federal level?
Federal.
Okay. And what do the federal rules of procedure say? Who is required to sign on a ruling on a motion? Is it a clerk or is it a judge?
I haven't read that part. I'm not prepared to answer
You might
that.
want to find it.
Section 8.
Okay.
Because I don't know of any jurisdiction that authorizes a clerk to do something a judge is required to do, which is rule on a motion of any kind. A clerk has that in and of itself is practicing law, making a ruling on a file pleading of a party in a court. That is a judge's duty. That's a judicial act. A clerk has no authority to perform a judicial act.
I agree. That's my point. So,
okay, so how do you prove the clerk did it?
I don't know how to. It's just something that I've kind of stumbled on. I don't want to go into depth because it's a little bit discouraging, but all right. Recently I had a motion before the court. Now, this is also a federal court, not the 10th District. And it's the first time I've ever had a motion ruled on the same day, just kind of off the cuff. In that motion, I indicated I would be submitting further documents, doctor's notes, things like that. Now, that was the quickest one I've ever had through that court. I filed the remaining documents recently, and it's been almost 3 days, not a word. So that's where I'm kind of making the distinction. If a clerk has some authority by the judge to just kind of quickly do easy stuff, but if it needs more attention, then we have to wait for the judge. That's kind of the differentiation I'm seeing. Have you had any?
The judge does not have any discretion to delegate a judicial function to his clerk, period. No matter what level of judge they are.
I agree.
So the question remains, is that what the clerk's doing? And if so, how do you prove it? Since you're not allowed to take recording equipment into those areas where that's being done, how are you going to prove it? I can only think of one way.
Okay.
A witness. And it must be a credible witness. Preferably, in this case, another judge or an attorney. But you better bring an attorney that doesn't practice in that court on a regular basis. Because attorneys don't like fingering a judge in as far as pointing the finger at them. Don't take that any other way.
None of them do. Well, I'll drop it here, and then this is way beyond what you guys are dealing with in this class, I guess. But I talked to an actual attorney who used to clerk for federal judges. She's now a dean of a law university out in Florida. She wrote a 70-page article about this and how many pleadings aren't even looked at by the judges. They're taken care of by staff attorneys or clerks themselves.
Yeah, exactly.
And she's seen it firsthand. That's why she's written about it. And she's not the only one. There's a lot of lawyers who know this goes on. But in the end, the judge signs whatever advisement they get from the clerks. I have a big problem with this. I have a really big problem with this, and I don't know how to prove it or get some attention to it. But I just was curious if you had any experience with it.
Oh, I've watched them do shit they're not supposed to do, clerks and judges alike.
The clerks run the court. They do everything, and then the judge just signs off on it. That's why I've seen it happen.
Well, it's also the prosecutors often run the court as well, especially when it comes to municipal judges and city attorneys or county attorneys appearing in that court. They'll tell the judge, since the judge, as long as it's not a court of record, the judge is often not an attorney. So whatever the city or county attorney tells the judge they have to do, the judge will do it. Because he or she doesn't know any better. So, but if you're talking about the federal level, that shouldn't be the issue. The judge should know exactly what they're doing. And they should know they're not allowed to do what you're describing, period.
Right. I understand, but how I've got them is I don't know how to, I don't want.
Now, also remember this though. You keep saying clerk, so let's discuss what we're talking about when it comes to clerk. There are clerks of the court, and then there are clerks of the court who work for the judge. They're the ones that does his legal research, writes his opinions. They do all that shit for these judges.
Right.
And the judge is supposed to review it and sign off on it if they agree with it. And but usually what will happen is the judge says, okay, this is the issue that's coming in this case. I want my opinion written to support it or denounce it, going for it or against it. I want these specific factors brought up and researched, and I want the opinion written to accommodate that. And that's what the clerk then goes and does. But that clerk is an actual attorney that is clerking for the judge. He is not a clerk of the court. He's a clerk of the judge. Those are different things. A clerk of the court has no authority to do what you're describing.
Okay.
But a clerk for an appeals court judge or Supreme Court judge, they do. Because what they're doing is they're acting on behalf of the judge to do the reading and the research and the writing, and then the judge is doing the review and the final sign-off.
Okay. I agree that's what's going on, and I agree that's what should be allowed to a certain extent. Here's the problem. In the 10th Circuit, there's 3 judges that are assigned to one case. That's supposed to be the oversight to make sure it's done properly. However, when a judge makes a mistake, actually misquotes a law from part of their 5 state districts, right? One judge might make that mistake, but not all 3. That's where I'm having a problem with the clerks that are working for the judges and doing this research. And I think the judges aren't even reading the cases.
Well, that's a separate issue. Whether or not the judge is doing their function of actual review is a separate issue from whether or not they have the clerk has the authority to do the things we're discussing. So those are 2 different arguments. So make sure you're clear on that point. Those are very different arguments. So given that, how do we determine whether the judge is actually doing the review or not? You're saying this is an appeals court, right?
Yes.
Okay. Which means you get to go above them on another appeal, right?
No. Supreme Court's next. That's it.
Right. Which means that court's above this court, right?
Sure.
Okay. So if this court is doing what you're claiming it's doing, and you appeal it above them to the Supreme Court, and the Supreme Court agrees with you, then these judges are going to get their knuckles wrapped for doing what you're describing.
Right. There's one more shot at the apple, though.
Which is?
I have a motion for a rehearing en banc. That means all 12 judges in the 10th Circuit.
Yeah. Well,
however,
go ahead.
How do I get to make sure at least a handful of those judges actually read my case and not the clerk advising the judges?
You start pointing fingers at the judges' clerks.
Okay.
You simply state, it is my honest I have reason to believe and do believe, based upon these factors, that the clerks for the three panel judges failed to properly research and interpret and apply the law, and the judges failed to correct it or to address it in any way, which indicates they never saw it. And therefore, I've requested a hearing en banc to have the court review this specific issue and why it's allowed to occur. And they either self-correct or it'll go beyond them to the Supreme Court and they'll correct it if they see anything wrong with it.
Yeah, that's some of the discouraging. I don't know. I've never been to the Supreme Court. This is highest I've ever been, but you know, 1 in 100 cases gets heard, you know, or something like that. But yeah, this is a big issue. I've seen some serious statistics about it. Now in the lower courts, I've heard, including Dr. Graves, he says, don't go to the Fed.
Yeah, if at all possible, don't. You have less protections in the Fed than you do the states.
Okay. I'm learning that
why.
the hard way. Yeah.
Yes.
So now I'm backing off all my cases into the state court. We're going to start practicing there and learning how to control the judges better there. Because I never thought I would have to control a judge at all. But learning that the hard way. So,
okay. Well,
all right,
just for the sake of conversation, whenever we're talking about them, so we understand when we talk in clerk what we're talking about. From this point forward, clerk of the court, that is just that, a clerk, an actual clerk. A judicial clerk is somebody who works directly for the judge, who is a licensed attorney and who is doing the things we're discussing. Everybody understand that? So from now on, if you have a question about a clerk, make sure you identify which of those two we're talking about. Clerk of the court or judicial clerk.
Hey, Eddie, I have something to say.
Okay, JJ, I can see you're talking, I can hear you talking, but you're talking from a bucket with a towel over it.
Oh, okay. Sorry about that.
So whatever you're doing, either get closer to your mic or take whatever's between you and the mic away because you're very muffled.
Is that better, Ed?
Not a lot, and you're further away than you were.
Oh, darn.
It's better.
All right. Yeah. Hey, I want to say when I was in the Supreme Court of Idaho, the Supreme Court clerk is also a judge. So it was weird how they were like denying my motion or whatever. And then I become the clerk and then they're a judge and a clerk. So isn't that interesting? Anyway, that's just an aside again.
Yeah, well, most likely if that's the situation where that you had a judicial clerk that was doing that. They shouldn't be the ones ruling on anything. The judge themselves is the only one that can actually make a ruling.
When I looked up the clerk's name, it was the same as the retired judge. On one of those senior judges is the same thing. It's interesting how that.
Okay.
Moving on.
All right. So let's go from there. Now, there's something else that I wanted to get into. Jane, you sent me a list of questions you wanted to add to your cross-examination. And you sent me a motion to recuse that you wanted to file.
Well, I'm not necessarily. I said, how does this sound on the motion to recuse?
Well, I'm going to pull them up and I'm going to go over them and I'm going to explain to you why.
Not complete.
Don't do that.
Not complete.
Doesn't matter if it's complete.
It's a rough
Don't do it. Okay.
I'm talking about when I go up there and they deny, if they proceed to trial, I need to file something while I'm there. A motion to recuse, objection for raise an exception for judicial error. It's in the rules of Texas appellate procedure is a reason why I went to those courts.
All right.
Trying to perfect an appeal.
All right. Well, we're going to look at two different things. First, we'll deal with the motion to recuse. Okay. Let's see. Share.
I don't even think that there's something we're going to go over as a rough draft. I was saying, how does
I
this?
understand it's a rough draft, but it's got some stuff in it that you need to be aware of, rough draft or not, because it still has to be fixed. But I don't recommend you file it because as of right now, I don't see why you would have a reason to file a motion to recuse, but we'll cover that in a minute. Right now, let's just see what's in it. It's 29.052. Local Government Code 29.052. Okay. 29, let's read it. Everybody can see the screen, right?
Yep.
Pursuant to Local Government Code 29.052, and when a party files a motion to recuse a judge. Why is "and" in there?
I don't know. Like I said, it's a rough draft. I haven't even.
The motion must provide with particularity the alleged grounds for recusal, and a party must provide notice to the other parties relevant to the case. Okay. Well, you see, the problem is, number one, 29.052 is not in the Local Government Code. There is no Chapter 29 in the Local Government Code. It's the Government Code.
Oh, that's right. Texas Government Code. Oops.
Okay. This motion must be filed 10 or fewer days before the date set for a trial or hearing. Okay. Where does this motion say there is no current date set for a trial or hearing? Therefore, this motion should be considered filed timely. Why is that not the statement?
This is going to be the day that they set it to go to trial. That I was going to file.
Jane, you're not listening to what I'm asking you here.
Well, I can't.
You don't have anything in writing that says that there is a trial date set, do you?
No, but I'm saying.
Okay, stop talking and listen to what I'm asking you. Don't go running off to explain shit I haven't asked you to explain. Stick with me. You have this motion must be filed 10 or fewer days before the date set for a trial or hearing. Okay? So, explain to me the difference between filing it for a hearing versus filing it for a trial.
Two different things.
I'm aware they're two different things.
One could be a hearing.
Why do you want to file one before one or the other?
It says either or, but I just wrote what it said in the statute right there. I just repeated what they wrote, just like they do.
Okay, but again, okay. What you don't have is you don't have a date for when the next hearing or trial is set, Jane. There's nothing to gauge the 10 days by.
I know there's not. This is for objections, motions that I'm going to file when I go there, when they deny my motion and they set the thing for a trial. That's what this is for. You said have a list of objections and whatever motions.
This doesn't say it's an objection, Jane. This says it's a motion to disqualify or recuse, doesn't it?
Yeah, and when he denies my motion, that's why I'm going to file a motion to disqualify or recuse.
Based on?
Based on his denying the motion, which...
that's not grounds to disqualify or recuse him, Jane, unless you can say he abused his discretion in doing it, or he violated the law in doing it.
You haven't read the whole thing yet. I was saying what the law says, and then I'm saying what the grounds are below that.
Jane, again, you set the stage as you go, not after. My point here is You have nothing to compare the 10-day time frame to.
I will have. I want these to be ready for when I go. I'm saying I can. This is a draft. This is not even complete. This is not even ready to go. I didn't know we were even going to read over this.
It still should be written to make sense, Jane. Even as a draft, it needs to make sense before you go back and make it right. You can refine the language after the fact, but if you've obliterated complete necessary details for the right location, you don't want the judge having to go all the way down through the motion to find, oh, well, we got something scheduled for this date. Is it really within 10 days? Tell them up front what you're doing and why you can do it that way. Set it as you go. That's the point I'm trying to convey here. Okay? As of the filing of this motion, there is no scheduled trial date or hearing date. Therefore, since this motion must be filed 10 or fewer days before such date, and none are pending, the motion is timely. Do you get it?
Yeah.
The government code further provides in section 29.055R. Are you sure?
Typo. The procedures at this court must follow.
Procedure following filing of motion. Recusal or disqualification without motion. So, Jane, this section would not apply because this is an oral motion that's being discussed in 055.
I know that.
Then why are you citing it?
Because still somewhere in there it says something about, again, it's a draft. Then I get to the particulars.
Anyway, real quick, let's read 29.055.
Yeah, it says a filing of motion without filing a motion.
And what I want to do is so everyone can see and follow along. Why does the damn chat window keep disappearing on this freaking thing? There's the link to what I'm reading, if you care to open it and follow along.
I can see it on the screen.
No, you can see your motion on the screen.
No, I see your screen. I see the.
You see the web browser?
Yes.
Oh, great. Well, that's fine. Then the thing's actually showing the screen instead of just a document. I like that better.
It's showing both of them. Now it's showing just the.
That's because I blew it up. So let's get where we can read it and everybody can see it. Procedure following filing of motion, recusal or disqualification without motion. A, before further proceedings in a case in which a motion for the recusal or disqualification of municipal judge has been filed, the judge shall. Guess what, Jane? If he's already made a ruling, what are they going to stop doing at that point?
They're not going to have anything else to do with it.
If he's made a ruling, then getting him disqualified or recused at this point doesn't change his ruling, Jane.
I know, but I'm saying I want to disqualify him from having any further action on the things. They have.
Then you have to do it before he makes a ruling.
Okay.
It would have to be the very first thing you do when you open your mouth.
When I go there for the motion hearing?
But again, what grounds do you have to disqualify or recuse this judge at this point in time?
Today, none.
Well, again, Jane, are you going to have any on the day you go to court?
Unless he dismissed the case.
And what? Well, if he... Okay, that's a self-contradicting statement.
No, if he dismisses it, I'm not going to have it. He don't need to be recused.
If he doesn't dismiss it, what grounds do you have, Jane?
Bias and interest.
Based on what facts?
Based on the fact that he did not read the motion. If he would have read the motion.
Which you're going to prove how?
That there's no way that he could have denied.
Again, Jane, that's an assumption. How are you going to prove it?
No, I can't see the motion anymore. You took it away. I can't remember.
1, recuse or disqualify himself or herself. Or 2, request the regional presiding judge to assign a judge to hear the motion. B, a municipal judge who, with or without a motion, recuses or disqualifies himself or herself, shall enter an order of recusal or disqualification, and A, if the municipal judge is not the presiding judge, request the presiding judge to assign any other judge of the municipal court, including the presiding judge, to hear the case. B, if the municipal judge is the presiding judge, request the regional presiding judge to assign another judge of the municipal court to hear the case. Or C, if the municipal judge serves in a municipality with only one municipal judge, requests the regional presiding judge to assign a judge of another municipal court in the county to hear the case. And 2, may not take other action in the case except that a judge who recuses himself or herself for good cause may take other action as stated in the order in which the action is taken. Okay? Now, C. A municipal judge who does not recuse or disqualify himself or herself, 1, shall forward in original form or certified copy an order of referral, the motion, and all opposing and concurring statements to the regional presiding judge, and may not take other action in the case during the time after the filing of the motion for recusal or disqualification and before a hearing on the motion, except for good cause stated in the order in which the action is taken. So tell me what Section 1 is telling us, Section 1 versus Section C. Because this is A. That's all of A. This is all of B. And this is C. So, what are the differences in the actions that can be taken between B and C?
Well, he is the presiding judge.
Well, is it a court with multiple judges, or is it a court with a single judge?
Oh. I think we might have another judge, like one that stands in or something.
No, Jane. Are there multiple judges assigned to this court? Yes or no? Like, for instance, Austin's got like 10 municipal judges in the municipal court, one of which is the presiding judge, and then all the rest of them are just judges that judge oversees. Okay? So, what's the difference between that kind of court and one where there is only one assigned municipal judge to the court? What part of the statutes apply?
I don't know. We went over this not very long ago in class.
Yes, we did. And that's why I'm sitting here wondering why nobody can answer the freaking question.
Well, you said something about it has to go to the regional judge.
Again, that's what this says right here, regional presiding judge. But what we're asking is first, what is the difference between B and C? There's B, and below that is C.
Does anybody
start at B? What does B say? A municipal judge who, with or without a motion, recuses or disqualifies him or herself.
That's voluntarily.
That's what?
What is the very first thing that must happen before any of the rest of this matters?
That he recuses himself?
Correct. And if the judge isn't the one moving to be recused, that would leave us going where?
To C.
To C. So B only applies if the municipal judge is recusing themselves.
Based on?
Doesn't matter what it's based on. If they're recusing or disqualifying themselves, that's when B takes over. C takes over when the municipal judge is not recusing or disqualifying him or herself. And the recusal request has been made by motion, which is A. That right there. Okay. Before further proceedings in a case in which a motion for the recusal or disqualification of a municipal judge has been filed, the judge shall, 1, recuse or disqualify him or herself, or request the regional presiding judge to assign a judge to hear the motion. That's the only options they have. Okay. So, number 1 sends you where within this same statute?
Down there to
A1 sends you to what part of this statute?
B.
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 A2 sends you to what part of this statute?
Plus. That sends you to the C section.
That sends you to C. So the statute has direct pointers as to which action a judge takes, as to which set of rules he must follow. A points the judge through either number 1 or number 2 to either B or to C, depending upon how the judge responds to the motion to recuse or disqualify.
What if they don't respond to the motion?
They don't have a choice. Okay.
So I filed a
The
motion.
judge shall. That's a command. That means there is no choice. He shall do 1 or 2. He cannot do nothing and proceed. And if you want to know how we know what shall means and that it's a command, go to chapter 311.005, I think it is where you will find the definition of shall.
I'm sorry, can you say that number again?
Texas Government Code 311.005, I think, is the section.
Okay. Thank you.
Mm-hmm.
So I filed a motion to recuse a judge before in JP court, and it worked. So this is not JP court, though.
Well, I don't see why a motion to disqualify would operate any differently. I'm sorry, it's 311.016. Everybody see this right here? 311.016. May, shall, must, etc. Shall imposes a duty. Okay, so the judge doesn't have a choice. This actually is this is probably the best written statute I've ever seen, because it shows you exactly what the correlation between the judge's actions and what part of the statute applies.
So,
Okay.
I need to do the request or the motion on a verbal motion, not.
No, you can do it in writing. Okay.
You should do it in writing.
You should always do it in writing. Okay. But the point is, let's see. A motion for the recusal or disqualification of a judge has been filed. Okay. This one doesn't say it has to be verbal, but the other statute that we looked at prior to this did. Let's see. Motion for recusal 052. A party in a hearing or trial in a municipal court, including a municipal court of record, may file with the clerk of the court a motion. That would be the one that's written, okay?
Isn't that what I cited, 29.052?
Is it?
I thought it was at the very beginning.
It is.
So then,
okay, but that is an explanation on how to file it. That's not what the judge must do in response to it. 29.055 is what the judge must do in response to the motion.
so then I shouldn't tell them what they're supposed to do. They just should know how to do it.
Okay, again, what you're citing here, okay, is how you have to file the motion. 29.052. That's
Okay.
irrelevant. What matters is what the judge is required to do in response, which is this one without the R. You get it?
Mhm.
I highly recommend you follow my practice and put hyperlinks on your statutory sites to
Mhm.
the site where you find it.
I do.
No, you don't. None of these have links to them.
I know none of this does. I told you it's a freaking draft. It's not even, I don't even have the right government code with this. I haven't even reread it, to tell you the truth. I just wrote it today. Just hurried up something. I'm just trying to get
Well,
response out of you.
again, if you don't want me looking at it, this is what I keep telling you, Jane. You do stuff like this, and I have to take it at face value because you don't make any clarification as to what it is in it.
I said, would something like this work? You know?
The government code further provides in section 29.055 the procedures this court must follow after the above motion is filed. In this particular case, Judge Acuna has interest in the outcome of this case and has a clear bias towards responding. What interest?
Interest in having me convicted
Based on what evidence?
based on the fact that he obviously didn't read the motion, or he wouldn't have denied it.
Here we go again, Jane.
Okay, but go further. Can't remember what else I said.
This is assumptions on your part, and how he ruled is not evidence of wrongdoing on his part. The only way you can prove wrongdoing on his part is if you can prove he acted in direct contradiction to the law.
Okay, he did do that too.
Based on what?
No subject matter jurisdiction. I think I covered that somewhere in here.
Again, we've made the argument that the court lacks subject matter jurisdiction and there's no evidence of subject matter jurisdiction in the record, but that's an appealable error for abuse of discretion. It's not an error for disqualification or recusal. There's a difference.
Okay, so you're telling me.
Understand something, guys. A judge can do anything they want as long as they do it a certain way. They must accurately apply the law. They must accurately follow the rules the way they're required to be followed. They cannot act with open bias and prejudice. And they have to act as fairly and impartially as they possibly can. Now, that may or may not occur. Okay? But when it doesn't, you make a record of it, you object to it. But that will not automatically get you a disqualification or a recusal. What will get you automatic disqualifications or recusals is an outright open admission of bias or prejudice from the bench, a conflict of interest that the judge can't sidestep, or a prior personal interaction with the accused that would definitely prejudice the judge against that accused. A personal interaction. Okay, like you hit the judge's car last week and damaged it. You used to date their son or their daughter.
So
et cetera, et cetera, et cetera.
So acting outside of his official capacity and the fact
Again, you don't have any proof they're acting outside of their official capacity. You may have proof that they're abusing their discretion, but that once again is appealable error, not disqualification or recusal. understand the difference, Jane.
I do understand now you're saying
Then
that.
why are you arguing with me, Jane? Because there's another great piece of supporting evidence. Because
if they're acting outside of subject matter jurisdiction and they're
again, Jane, we've made the argument they don't have it. When we prove they don't have it on appeal, then and the court above them agrees with you, then you've got evidence. Till then, it is simply your opinion based upon your interpretation and understanding of the law that this court lacks jurisdiction on these grounds. If the court proceeds beyond that and you are right, then it becomes an abuse of discretion. If you are wrong, then the appellate court's going to hear it and rule against you just like the trial court did, won't they?
Well, then are you saying that there's not going to be a situation, there's not going to be a reason to have this judge recused?
I just gave you the reasons you can have this judge disqualified or recused, Jane.
I know you did.
You will not get to use how they're ruling on your pleadings as grounds for any of this unless you have absolute admission from the bench that the ruling is because of prejudice or bias.
Well, then scratch this motion because it's not going to work then.
Which is why I'm telling you at the very beginning of class, don't file it. Don't try it.
All right.
And I'm trying to educate you as to why. May I continue?
Mm-hmm.
In this particular case, Judge Acuna has interest in the outcome of this case, something for which you have absolutely no evidence, and has a clear bias towards the respondent, something else for which you have absolutely no evidence. You're simply saying that based upon the fact that he doesn't agree with how you think things ought to be done. That's not grounds to recuse or disqualify. Acting contradictory to law, that would be grounds. Acting contradictory to the rules of procedure, that would be grounds. But only if you can prove that it was based upon a prejudice or bias or a malicious intent, not an abuse of discretion. If it's based on an abuse of discretion, then it's only going to be responded to on appeal. Period.
What about malicious prosecution?
That the judge is the one prosecuting you.
All right. Well, the motion to recuse the judge in the JP court happened after she ruled, and that's the reason why I didn't want her.
Well, again, you can't file a motion to stop them from doing things after they've already done it.
That one worked.
After that, it's an appealable error. It's not anything else after that point. You file a motion to disqualify or recuse to prevent a judge from taking any further action, not because you don't like the action they took already. Got it?
Yeah.
Now, another statement. If Judge Acuna had actually read respondent's motion to quash or set aside, what's your evidence he didn't?
If he didn't rule on it.
Doesn't mean he didn't read it, does it?
I don't know. You're the one that's been saying that he probably didn't even read it.
Probably is still not the same thing as saying what you're saying here.
Let it go by and get by operation of law get denied.
Well, then why don't you actually say respondent's motion was denied as a matter of law because Judge Acuna made no ruling on the motion, which indicates one of two things. He didn't care to read the motion and look at the legal points, or he failed to read the motion and didn't look at the legal points.
Well, it hadn't happened yet, so.
Okay. That's telling the truth and that's being factual. What you wrote here is entirely speculative on your part, and it will carry no weight because this is what the court would call a legal conclusion with no supporting evidence.
Well, it hadn't happened yet, so.
Again, not relevant to the point we're discussing, which is why you need to think before you write or speak.
Okay, is there anything else I wrote in there? That would
There's
help.
lots of things you wrote in here, but I ain't got to the second page yet, so hang on.
I can't remember exactly. It was even more than
And
one.
now you conclude this sentence with, had he agreed with you, then he would have ruled to agree with you. That's what you actually say here. But you wrote it like this. He would not have come to any other conclusion other than the dismissal of this case with prejudice. A sentence that makes absolutely no fucking sense grammatically. But if I read between the lines and try to say what you're trying to say, then what you tried to say was, if he'd only just agreed with me, he'd have seen why I was right.
Yeah, he would have. I mean, there's no way.
Does that statement not sound completely ass backwards to anyone else in the class? If
Yes.
only he'd agreed with me, he'd have seen that I was right.
If only he would have read the motion
Yep.
and understood the motion. Yeah. And,
Just
obviously,
because he read the motion doesn't mean that he would agree you're right, Jane.
anyway, we left no rat. We left no escape for the rats to get out. So,
Well, actually, I would disagree with that statement as well, because so far you haven't built a trap.
I'm talking about in your motion to quash. There's
In
no,
my motion to quash, I didn't do what?
there's no escape for the rats to get out.
Correct.
That's right.
But that is exactly why that motion's written the way it is.
Right. And that's why I'm saying if he would have read your motion to quash, set aside, then he could have not come to any other conclusion other than to dismiss it.
No, he still could have disagreed with it. But then you have appealable error for abuse of discretion, don't you?
Okay. All right, let's go further. Go ahead.
The decision to set this case for trial is proof that the judge took no action. No, it's not. And most likely did not even read the respondent's motion. It's not proof of that either.
I'm sounding like the prosecutor.
Well, now you know why the prosecutor can get away with sounding this way. Because you're giving them every reason to tear your reasoning apart.
Yep. Okay.
The complaint fails to allege an offense against the laws of the state of Texas or against any city of Irving Code of Criminal and Civil Ordinances. Again, Jane, long-winded, but okay. We made that argument in the motion to quash or set aside. Okay.
I know.
That has nothing to do with the motion to recuse. What would have made sense here is the judge has openly failed to apply the law to the facts in a manner prejudicial to the defense in this case.
Okay.
That would have been an argument. That would have been something the judge would have to respond to. That would have been something you could have got the regional judge to look at and go, yep, disqualification or recusal is appropriate in this case, and I'll assign another judge. But what you wrote here isn't going to get you jack shit but laughed out of court.
I'm not surprised. It was just thoughts.
The initial citation failed to allege a complaint, and the sworn statement written, the complaining neighbor, also failed to allege an offense.
Yep.
What the hell?
Written by the complainant. I just typo.
Okay. Animal Control Officer Natalie Delgado issued respondent. See, you're making factual argument about the facts of the case. Why is that in a motion to disqualify or recuse the judge?
Well, I'm just trying to show the judge what he missed out on by not looking at the motion.
Again, the
the whole thing is just a
the
shame.
whole statement is wrapped up in what I said before all of this. Judge, whatever the fuck his name is, has failed to properly apply the law to the facts or the case law to the facts. Okay? Showing an open bias and prejudice against the defense in this case. Therefore, I move for the judge's disqualification or self-recusal.
That sounds better.
No shit.
I know. So I'm
And
saying
that's not meant to sound bragging. It's just meant to be, I contemplated what I needed to say before I wrote it down to say it. Now, granted, if you're writing a book, you just get all your thoughts on paper. Then you go back and clean them up.
Yeah.
Then you go back and make them sense. You do that with a legal pleading, you're going to wind up with a Swiss cheese of a fucking pleading, and it's going to cost you.
You know how many drafts I end up coming out before?
Okay, I don't care how many drafts you start with. Let me give you guys a lesson in legal writing 101. Okay? I'm going to save this, and then I'm going to close it. And I'm going to start an all new document. Let me get these others out of the way.
What about the other questions?
What other questions? That you only had 2 pages in this thing.
I'm talking about the questions that I was going to add. I wanted to add, or suggest.
No, and real quick, I'll go over that too. Let me pull that up because I also had that on the list of things to discuss. So, where in the there's Word document. Let's see, file. No, okay, I didn't open it yet. Come on, give me my damn toolbar, you stupid thing. Thank you. All right. All right, real quick. You wanted to add these questions. Please tell me how this would be relevant to your case.
Hang on, I'll get back to the screen. Okay.
And I guarantee you, you ask this question, the first thing that's going to happen is the prosecutor's going to object on relevance.
What was this has to do with public health.
I know what it's titled as, Jane. I'm looking at question number 1 under danger to public health.
Any medical assistance or medical emergency calls made by anyone from Ventura Park in the whole community here.
How the fuck would the animal control officer know any of this? How in the fuck is this relevant to the facts of your case?
It's because I'm talking about, you said ask questions that are related to public health. And this is, I'm not saying that this is related. I'm saying that, are you aware of any of these things happening?
Jane?
As a result of my allegations of my feeding my animals outdoors.
No, you're not asking that question. You're not asking that question at all.
As a result of the alleged feeding of animals outdoors. Sounds like I am.
But it doesn't say you feeding them outdoors at your residence, does it? No, this is very general and open-ended. Have you heard of any calls from anybody in all of Ventura Park about allegedly feeding animals where there was a medical assistance or medical emergency report made? How would the AOC know that? Or ACO know that?
I don't know, but maybe
you don't know, and neither would they. And there's no indication as to how this is relevant to the facts of your case. Has nothing to do with you specifically at all, does it?
Okay, after you finish these, I will tell you where I got these questions at. But anyway.
I don't want to know where you got them from. I'm telling you why they don't apply. Okay? Now, what's the difference between the way you're asking questions about danger to public health and the way I asked them in the script that I did for you already? What's the difference?
I've already got those in a cross-examination. This is something new right here.
I know what this is, Jane. Never mind.
Okay. So
it's
that's
like trying to explain color to a dog. Shit.
You
You did not see any medical waste, toxic substances, or contaminated materials on the respondent's property, did you? Okay. Well, first off, they're not going to know who the respondent is. And what does medical waste, toxic substance, or contaminated materials have to do with your property or this case?
Public health.
I know where you're getting this. You're trying to get this from the state's law on what constitutes a danger to public health. Right?
Sort of through AI. Yeah.
Did you feed the city ordinance into the AI engine?
I fed everything. I fed our whole motion in there.
Well, first off, Jane, if you're going to use Chat GPT or any other AI bot to do this, you damn well better know how to write the query and write it well. And you better understand the information you're feeding it first and foremost, so that you can determine what the information coming out of it is worth.
I did, and then I changed it, and I changed it again because
well, obviously you don't, because if you did, these are not the questions you would be asking, because you would realize two things. Number one, this is all very general and could apply to way more than just your case.
Just like the charge, the elements of the case, just like that. It could apply to anything, just exactly like what they're doing to me.
Jane, listen to what I'm telling you.
Okay.
What you're asking here covers a wide swath, not you, not your animals, not your specific actions. It covers anybody in Ventura Park.
Okay. Well,
therefore, this is a question that you're not going to get an answer to because of the two things we said. Not relevant, and most certainly not within the knowledge of the witness.
Okay, you'll scratch number one. And as
well,
far
let's go to number two. You did not see any medical waste, toxic substances, or contaminated materials. What qualifies the ACO to know what is medical waste, what is toxic substance, and what is contaminated material? What qualifies this witness to know that?
Where in the ordinance is defined what a danger to public health and safety? How am I supposed to know what that is when it's not defined? I'm doing like what they're doing to me. I don't know.
That's a good way for you to lose your goddamn case. Now stop screaming at me and listen to what I'm asking you. Answer the goddamn question. Stop flying off the handle. You don't get to play stupid and victim at the same goddamn time.
I'm just defining what a danger to public health and safety is.
No, you're not. You're asking questions that have nothing to do with your case. Where is the question about what is the state definition of danger to public health? That would be a question about what you're asking. It would be a question they don't have to know the answer to. It would be a question that would draw objections from the prosecutor, and they would be sustained by the judge.
I think number three is relevant.
Well, let's find out. Let's start by finishing number two. You didn't answer my question. What qualifies the witness to testify as to what is or is not any of these things?
Well, I would have already told her I was respondent. And let's see here.
I don't know when you would have told them that, but that's still beside the point. I didn't ask you about who the respondent is. I asked you what qualifies this witness. Any of the witnesses they're going to call, any of them, what qualifies them to know what constitutes any of these things?
I don't know that. Just like that. I mean,
then why would you ask the question? If you don't know what the answer is, and you don't know that they are going to have that answer readily available to give it to you, why would you ask the question? Because it's exactly the same thing as asking why. And what have I told you guys about asking a witness why on the stand?
I'm not asking why. I'm saying
you never ask a witness
you
why.
only ask that if you know the answer.
No, you only ask that if you are absolutely certain the answer you know is the only one they can give you.
Right.
Well, they can't say they can't say yes to that. So
of course they can. It's not a yes question.
It is to
It's not a no question. No, it's a how would I know that question?
You did not see any medical waste, toxic substances, or contaminated materials.
I'm sorry, but I'm not an expert in what medical waste is or what toxic substances are or contaminated materials. And even if I did know what they might be, I don't have any way to test them to know if they're actually any of these things or not.
Okay, move on. Question 3.
You did not collect any surveillance, video, any surveillance. Explain what you mean by any surveillance. How do you collect surveillance?
Surveillance video or.
Well, that doesn't say surveillance video. It says, did you collect any surveillance? Then there's a comma. And then it says video or photo.
All right. Showing wild animals eaten from the bowls or trays on the defendant's property, correct?
Did I not already ask this question in the questions I gave you? Because I guarantee you, if I did, and you ask it again like this, it's going to be objection, asked and answered.
I'm not saying that I'm changing what's already in there. I'm saying these might be some of the questions that we could ask also, period.
Do you see how you answer things I didn't fucking ask?
No citizen made a complaint to the health department and mentions illness, contamination.
That's 4, not 3.
We're already past that.
No, we're not. You haven't answered my question about 3. It doesn't, the word surveillance doesn't even have to be here. And you're saying you did not collect. Who? Who are you asking these questions to? Delgado?
That's Delgado.
Okay. You did not collect any video or photos showing, or you don't have any video or photos showing wild animals eating from bowls or trays on the defendant's property, correct? But again, the ordinance doesn't say a fucking thing about wild animals, does it, Jane?
They're saying that they're
Stop
prosecuting.
it, Jane! Answer the question I asked.
The ordinance doesn't, but the prosecutor is saying that that's the reason why they're prosecuting me, because of the wild animals.
I don't give a jolly goddamn what the prosecutor's saying, Jane. Focus on what the goddamn ordinance says. Focus on what I'm asking you.
Creating.
The reason we have problems is you don't fucking listen and you don't answer what you're asked. Try that for a change, for God's sake.
Questions. I told you these are suggestions that I got. I'm asking.
And I'm trying to explain to you why you don't go chasing suggestions without reasoning them out first. So we're doing that by analyzing what you're thinking when you wrote these questions down.
Copy and paste.
Well, again, what you asked an AI engine to generate with God knows what it fucking input. You put in a motion that you wrote, right? Or did you put in the one I wrote?
One you wrote. Anyway, so what else is in here?
The one I wrote does not contain it does contain the entire ordinance. But the problem with the AI engine is it doesn't understand ordinances and statutes. You know why I know this?
I put those there too. But anyway.
I know this because I took a section out of my book that contained statutory references complete with hyperlinks. And I expressly told ChatGPT to review and word more succinctly this paragraph without removing active hyperlinks or references to statute. You know what it gave me? A paragraph with none of that shit in it.
Yeah, you rely on it all the time when you ask questions and you say that it's right.
No, I don't. If it comes up and tells me that I got an AI response on Google, I go check all the other links below the AI response. I don't use the AI response unless I know that the answer it's given me is accurate or I can verify it. Now, I may look at it and go, well, this is what it's saying, but let's see if there's something that contradicts it. That's why we went to the statutes when I was getting that answer about the Dallas County Court of Appeals, what cases they can hear. The AI is saying they don't have the jurisdiction, but the statute says they do. So the AI is untrustworthy when it comes to issues regarding law.
I agree.
So why the fuck would you give it a motion to write?
I didn't give
or to read for that matter. Like I said, if you don't word what you put into an AI engine the right way, you will not get the result you expect back.
1 second.
Number 4, No citizen made a complaint to the health department that mentioned illness, contamination, or exposure to disease, correct? Does the ACO work for the health department?
No.
Then how would they know this?
I don't know.
Yeah, neither would they. So you're not testifying today that any specific, and see, you jump right over from 3 to 5 with the wild animal thing. So you're not testifying today that any specific wild animal was actually observed feeding on this property, are you? Again, ordinance doesn't say a damn thing about wild animals. What does it say about animals specifically, Jane?
No.
That would be E3, right? If
Yeah.
I'm quoting it from memory correctly, E3 is where it talks about more than 10 adult animals.
Yes.
So they don't have to be wild, do they? But what there does have to be relative to animals is 10 or more than 10 adult ones, right?
Yeah.
So what should the question be when it comes to animals?
Were there more than, did you see more than, how many animals did you see? Or
No,
did you see more than
that's
10?
an open-ended question, isn't it? And you're doing cross-examination, aren't you?
Did you see more than 10 animals gathering around a food source?
No, still the wrong way to word the question. Remember, you want to be putting words in the witness's mouth on cross-examination. Therefore, you want them helping you, not hurting you. So word your question in a way that the answer you get will help you. Miss Delgado, you did not personally witness more than 10 adult animals congregated on the defendant's property, did you? No. And you have not viewed any video or photographic evidence of more than 10 adult animals congregated simultaneously on the defendant's property, have you? No, I have not. Do you see the difference in those questions versus what you're writing here?
Mm-hmm.
You're letting them and what you think they're going to say and do dictate how you address the ordinance. Don't.
Mm-hmm.
The ordinance says what the ordinance says, no matter what these fucking morons do. If they say, well, it could have called wild animals. Objection, Judge. There is nothing in this ordinance that talks about wild animals. Absolutely nothing. That is a red herring question by the state, and it's meant to deceive the court, and I object. That's how you deal with that. You don't do it by asking questions that help the other side and gives legitimacy to the errant point they're trying to make. You don't talk about wild animals because other than to object to any mention of them because they're not mentioned in the ordinance. Period. Anything else is an argument that grants legitimacy to their assertion that it matters when it doesn't.
Well, they don't have a case then, right?
Well, we know they don't have a case, Jane. It still doesn't mean you don't have to do what you need to do and do it right.
I understand that. This could be after the prosecutor has already said.
No, Jane, there's not going to be any after. They're going to do direct. You're going to do cross. Cross is where you get this in, period. Therefore, you do it right. Now, let's go to 6. Are you aware of any 911 calls made to the Irving Police Department for animal attacks in Ventura Park? Once again, how would an ACO know that? They're not the one called on 911. They're contacted by another agency if it's animal related. If someone calls 911, it goes where? Fire, ambulance, police, not to animal control. 311 will get you animal control. 411 will get you animal control, but not 911.
I'm trying to figure out where they're coming up with public danger, public safety.
What?
I'm trying to figure out where they're coming up, how they're alleging
They're
that.
making it up, Jane, which we already know. In fact, on March 23rd, 2025, the day you wrote the citation, you did not observe any animals at all on or even near respondent's property, did you? How do you know what they observed?
Because there was none there.
You're positive.
Property. I know for a fact, 100%.
Does she know what property is yours?
Yes.
You're sure? She knows what the boundary of your entire property is.
I know that there was no animals anywhere in sight, anywhere.
Jane, you're not answering the fucking question I just asked you.
It doesn't matter if she knows the boundary. She saw me.
Yes, it does, because all you asked is respondent's property.
It's not. It's not like there are a whole bunch of animals running around over here. She didn't see birds, cats, dogs.
Again, not the point I'm making and not the question I asked. Someone tell me, if the animal control officer is saying that you're feeding animals outdoor and they take pictures of the plates you're using to do that, how should you word this question in order to ensure you get the answer you want and the prosecutor can't object to it?
She didn't take pictures of animal food bowls. I'm just telling you that right now.
One of the reports said she did.
That was the other case.
Again, Jane, as a fucking example.
Well, you keep confusing that one with this one.
Again, do you know what she did or did not see the day she issued the citation, Jane? Do you know for a fact that she couldn't see the plates from where she was at any time?
There's no plates out there. I was leaving.
Okay, again.
She didn't even come up to my property. I was outside when she pulled up. She didn't do anything but get out of her truck, come over to me, give me a citation. Period. That's all she did.
Did she block you in your driveway?
No, it's a cul-de-sac kind of like thing.
Okay.
Kind of.
Again, answer the question I'm asking. What is a better way to ask question 7 if question 7 was actually relevant? Anybody? Come on, anybody. Y'all can see the question. Find a way to write it where it would make sense.
I don't think it makes sense.
You think it makes sense?
Except for even near respondent property. Should have just said any animals at all on respondent's property. Did you?
Again, how does the ACO know the boundaries of all of your property?
I don't know. It's just like
exactly, which is why the question would get objected to.
Well, then what is the location that the alleged criminal action took place?
Well, again, you would need foundation to ask a question about the animals, wouldn't you? So if you were asking the questions properly up to this point, you would have laid the foundation as to, did you observe any animals being fed? No, I saw it in the video. Well, what exactly did you see in this video? I saw 3 cats. Well, where were these cats? Well, there were 2 off in the distance up toward your front door, and there was one on the hood of a car closer to the camera. Okay. How many total cats would that be then? That'd be 3. And 3's way less than 11, isn't it? Yeah. Then can you please explain why you issued a citation for feeding animals? Because you were feeding them outdoors. Oh, so you're saying that the ordinance says that it's actually illegal to feed an animal outdoors. Is that what you're testifying to? Yeah. Judge, I asked that the ordinance be admitted and the witness be allowed to read it. And please identify to the court where the ordinance specifically says it's illegal to feed an animal outdoors. That's how you build up to that kind of question. You lay the groundwork for it, so nobody's lost. Okay? But you're jumping over shit and you're not laying foundation. You're just jumping to things that you've laid no foundation for. You're asking things that the witness cannot possibly know the answer to.
These are not my questions to ask I took my questions from what we had in the video. I'm asking you if any of these questions would, we could add any of these questions.
Well, you sure are getting pissed off like these are your questions.
No, I'm saying that you're getting all in a tizzy over something. You're saying that I'm changing, this is in concrete or whatever. I got your questions that we've gone over in all these classes as my cross exam. I'm asking you if any of these questions could be added,
Well, let's see. So far in the first, let's do 8. So you are basing the citation that you wrote on this date from what your opinion is of what the ordinance says, correct? Okay, that doesn't even make any sense the way you wrote it, or the way Chat GPT or whatever the hell AI engine you put it in there wrote it. Are you saying this came out of the AI engine?
That might not have.
Yeah, that might not have. This is all you, isn't it?
Your base citation you wrote on from what your opinion is of what the ordinance says, correct? That's what she told me out there in the street.
Okay, again, you've laid no foundation for this up to this point. You haven't talked about the citation except for the question right before it. Okay, and you haven't laid any groundwork for why you're asking for their opinion. But again, irrelevant. Not a good question. Not the way you're asking it.
I don't know why I asked that anyway. I meant to ask.
What you should have said is you issued a citation based on something the ordinance does not actually criminalize, correct?
That's that even needs to go, because what she told me out there was she was issuing the citation on behalf of the complaining party.
But she didn't witness it. And that's the other thing, see? In Texas, these people, when it comes to misdemeanors, they can only issue a citation for what they personally witness, what occurs in their presence or view. They can't do it simply because someone filed a complaint.
Really? How come we haven't put that in the motion?
Again, they misapplied the ordinance. We take the bigger hammer, Jane.
Okay.
Okay. We don't have a gift. We do not have to give a name to every hair on someone's head before we shave it.
All right.
You get me?
Yeah.
All right. So let's assume that all the other questions are very similar to the first set of questions. Okay. Now, who is danger to public safety? Okay. Again, this is still Delgado. You made the claim that feeding of animals outside is dangerous.
Yeah, it's still Delgado.
Okay. Well, what is false about that statement?
We made the claim that females are something that you never had.
She didn't make the claim.
Yes, she did.
You're not following. Even if that is what she said, what makes her statement false?
That the animals, feeding of animals outside is dangerous.
That makes her statement false? If you're standing there feeding the wolf outside, would that be dangerous?
No.
If you're standing there feeding a bear outside, would that be dangerous?
Yes.
So the statement is not false. Feeding animals outside is dangerous if they're the wrong kind of animal. So the question here is, what kind of animal are you alleging was being fed? Are you saying that the animals that were fed, in this case, house cats, are in and of themselves dangerous? And if she says yes, then can you please identify where the ordinance specifically says that house cats are dangerous and therefore it's illegal to feed them outside? That's how you prove her statement is false. The way it's worded here wouldn't get you jack shit. And I know this didn't come out of the AI either, did it?
I don't know. I can't remember.
I can, because it's directed specifically at her about something she allegedly said that's not in the motion. Therefore, AI didn't cook this up. You did.
Well, I was gonna put what the question was to the AI engine in the chat, but it was too many characters. So
Okay. So, needless to say, throw out both of those documents. Let me finish the cross-examination script I'm working on. Okay? Now, back to what I was going to do here. All right. If you're going to write a legal pleading, do not start with a legal pleading. You get me? First thing is start with the statute or ordinance that you're being charged with. Outline it according to the elements. That would be like section E, Jane. Okay. General framework of the ordinance would be sub 680-E or A and E or 1 and E. Okay. What's at the very top? The general declaration of the statute. Okay. That's the general framework. Okay.
is anybody still here?
Looks like most everybody's still here. All right. General framework of ordinance or statute. Okay. And then under this, you're going to sit here and put in everything that would be an element out of that general framework language. In this case, owner of an animal.
Actually, we lost about over half of them. But anyway.
Okay. That is the takeaway. All right. Now, do you have the ordinance in front of you anywhere there, Jane?
Yeah. What, the whole thing?
Well, specifically subsection E.
The part where it says a person that commits an offense?
This
Yeah.
section right here.
Oh,
Yeah.
Wonder if anybody else had anything to ask you.
Well, if they do, they can ask. Okay. In this case,
Eddie,
yes.
so if you have an appeal, could you register your car?
Say that again.
If you're appealing your case about registrations, could you register your car at the same time?
I'm still not understanding that.
If you appeal your
The
case,
part right before at the same time. What are you saying there?
if you appeal your registration case, can you register your car?
Yeah, you can register
your
anytime.
car.
You can
What?
register at any time, man.
Okay.
But should you?
Yeah, why should you?
Because
Yeah.
in the complaint letter, they say if you register your car, you will accept defeat or something. If you register your car, the case is done.
You accept the jurisdiction? Is that what you're saying?
Yes.
Yeah, if you register your car, are
Yeah.
you registered?
What?
I mean, are you not going to register your car when you get your car?
I mean, that's a way to win. Get the registration case dismissed.
Interesting.
Isn't that right?
Yes. If you register your
They
car,
would waive the charge.
That's what he's getting at. Like, he's asking about getting the registration so the case can be dismissed. Like, you can register at any time.
no, what I'm saying is, I want to dismiss the case.
Yeah.
But if I register the car, the state will dismiss the case because of that.
Usually how it goes, you provide the proof of permissions and case dismissed. Usually how it goes.
Yes. But I don't want my case to be dismissed that way. I want to fight it.
Okay, well then
Don't register the car.
Don't
yeah,
register.
you got to do Article 3, Paragraph 2, Section 2. When a state is named a party, the Supreme Court has original jurisdiction where your constitutional challenges will be heard.
Yes.
Do you own
Must be different in Texas and
Missy
Oklahoma.
Prius courts, these lower courts, they only listen to statute, policy, and code because they
lower
think you're
court
the
don't-
corporate
they don't-
fiction.
The
No,
lower court don't-
stop. Drop the corporate fiction shit. That's not how it works. It's never been how it works. Never,
Hello?
ever, ever. That is patronage
thank you
shit.
for that.
That doesn't survive here.
The lower court just ignore the statute.
They always ignore.
This has absolutely nothing to do with straw men, corporate entities, the fucking post office, the Queen of England, the Pope, or anybody else.
All right, so I might have gotten that corporate fiction thing wrong. I can agree to that. And all the rest that you said. Yeah. Nonsense.
What about fighting a case with using criminal complaints and proving that somebody doesn't have the lawful authority to prosecute, like if they didn't have an oath of office? Is that a good
Why
way?
do you want to go down to their level?
That's why I'm
Bring,
somebody-
and cite case rulings. It's not case law, it's rulings. Judges don't make law. Administrators don't make law.
It's judicial opinion.
Thank you, sir.
Yeah, there was somebody in.
I don't like the title thing, but that's the best respect I can give you.
Well, I don't need it. I'm not here to be respected. I'm here to try to get you to learn how things work. That
I hear
people can take it or leave it at their will. They don't have to be here. I'm glad that they are. Don't get me wrong. And I know I'm not perfect and I'm not always right. And I don't pretend to be. But
You're never right.
I do my damnedest to be right before I open my mouth. Not always true.
No, you ain't never right, bro. You're always wrong. Get out of here, Eddie. Come on,
Most of the time.
Anyway,
All right.
would it help Kevin to put his car into a trust?
Nope.
No.
None of that has anything to do with why they're writing tickets. It has nothing to do with how to defend against the tickets or anything that comes with them.
Okay.
The law is what the law is. If you know what the law is, then that's how you would use it to defend against it.
Okay. That's what I'm here to learn.
I got a quick question on Joinder. So if three people are joined in the same case, two of the people get the case dismissed. Can the prosecution still use the same the same evidence to convict the third person?
Wait, say that again.
Sorry. So if 3 people get pulled over in a car, right?
Right.
The driver gets arrested for driving on suspension. She actually has a valid license. They all 3 get charged with the possession of controlled substance, which is the driver's prescription pills.
Wow.
Well, one, if the driver has a prescription pill and it is the correct pill in the correct bottle and labeled as a prescription item, that charge would fail in court as long as your attorney's any good anyway. And the thing about it is if the rightful owner of the pills is in the car, then the pills have a right to be there.
Yes, you're right. Yet they still press the charges, and the attorney still press forward. And then
the prosecutor, you mean, or their defense attorney?
Their defense attorney.
Their defense attorney saying that this is okay?
Uh-huh.
Their defense attorney is a fucking moron.
I agree. But on the Joinder thing, if the 2 people get their charges dismissed, wouldn't the 3rd person also have the case dismissed also?
Well, if the facts are what you say they are, and the attorney does what he's supposed to do, nobody should get charged with anything other than the traffic infraction, whatever that may have been. But the drug charges wouldn't hold water for 10 seconds if the attorney went after him for that, and the facts were in his favor. That was her prescription. It was the right pills. It was in a prescription bottle, and she was the one in possession of it in the car. Or it was in some place in the car, and there's no evidence that anybody else either A, knew they were there, or B, had access to them, or B, ever accessed them. If they did know, and whatever.
So probable cause for the pullover is the LPR reading hit as a suspended prior. And
when they ran her license, that should have come back negative. But if they didn't do their investigation and run their license before they entered and searched the car, and they had not yet made an arrest, and she didn't consent to the search, did she?
No. She was ripped out the car before she could get the license.
Why you lock your doors?
So why isn't there video of this?
Because the only video that they have is the very last cop car in line, and that's it.
Okay.
There's no body cam or dash cam footage of that?
The only video that they got is the very last cop car in line. So you can see the cop open the door and pick her rip her out of the car, and that's about it.
Why didn't you guys record?
From how long when he got out of his car to her car, how long did that take?
Probably minute and a half, if that.
Okay. And there's no audio of what's being said at that time.
Nope.
No one in the car thought to start recording when they were getting pulled over.
Nope.
These officers have no body cams?
No, nope. Oh, they do, but they're messing up at the point in time of the traffic stop.
On
Allegedly.
Purpose?
Allegedly.
That's why you follow
again,
80
if this attorney's not willing to fight for them, I need to fire him and get someone else.
Yeah.
Gotcha. I told her she'd be better off fighting it herself, basically.
No. Not when there's jail involved. If you don't know what the fuck you're doing and it's a criminal charge that can send your ass to jail, you better find a fucking attorney. And you better find a good one. They ain't going to be cheap unless you're married to them. And even then, that may not be such the case.
So with the judge at hand, every attorney is like, yeah, Marshall, yeah, it's a problem. 20 grand.
Well, again, I can't speak to what the attorney charges. That's not the issue here.
I got you. I was just
the issue here is, can they properly defend themselves against the charge? No. Highly unlikely.
No disrespect, Eddie, but I fought my own case by myself here, and it was jail time that I was looking at.
Again, I'm not saying that no one can do it. I'm saying in general principle, if you don't know what the fuck you're doing, for instance, there is no way in hell I would ever recommend Jane defend herself if the sentence is jail.
Oh, I completely agree.
Okay. I'm not saying that's true for everyone. But if you're talking about somebody that didn't know enough when they were getting pulled over to at least one of three people pull out a fucking camera and start recording.
Oh yeah, always film the police.
Then why would they walk into a courtroom with no evidence that would help them?
Exactly.
Okay. I'm not saying it can't be done. I'm saying on general principle, if that's the potential outcome, it should not be done. Okay. But then again, there comes a time when you can't trust an attorney, any attorney, to do what's right on your behalf as the defendant. And therefore, you don't have any choice but to fight it yourself.
Right. Well, here,
I mean, my friend Ruby, they were trying to send her to prison for trafficking drugs because a confidential informant for Bexar County Sheriff planted an entire kilo of meth in her house and then informed on her to the Bexar County Sheriff's Department, and they raided her house the next day. It was a complete setup. She couldn't get an attorney for the entire 5 years. She was waiting to get her day in court. And fortunately, she never allowed the attorneys to enter pleas for her or do anything like that and refused to plead guilty or take a deal. That forced the attorneys to either get off the case or to do the work. Well, it turns out until we got the news crew in San Antonio involved, nobody would do the work. But the news crew did the investigation and proved that she was set up based upon paperwork that I wrote for her to file, challenging the court's evidence and everything else, and getting her attorney. I wrote up a contract for her and her attorney, saying that the attorney is to protect all of her rights at all times and is not to waive any of them without her express consent. And every time she put that in front of her public defenders, they quit.
Well, yeah, because that's like an ethics issue or something, or misconduct.
Yeah.
Because they're supposed to
But
fight for your
because I
right.
wrote that up and said, you make damn sure any attorney that court signs you, you give them this and tell them, you're not my attorney till you sign this. And the next thing they did, they went to the court and says, we need to be let off this case.
Yeah.
We did that for 5 years. It kept her out of jail. It kept her out of prison.
Yeah, that's the issue that I ran into here, is that none of these defense attorneys around here are willing to actually fight
even
for
if you
your
pay
rights.
them, there's no guarantee they're going to work for you.
No, they're trying to do backdoor deals and everything else.
All right. Now, can everyone see this ordinance and the highlighted portions here?
Yes.
Okay.
Oh, I can.
This right up here at the top, this is the general framework of the ordinance. Okay. Let me see if it'll let me copy it. And just so we can make it corresponding to the document.